With this asynchronous session, I wish to introduce you to the manner upon which we engage in business. And when a commercial transaction takes place, when a contract is entered into, when business happens, when we are making decisions of a business nature, we are either acting in our capacity as an agent for another. We're employed by a company and we are acting as their agent. We are acting as their employee. And this will be where most of you are in the next decade of your lives. You'll graduate, you'll take employment, and you will have a span of control, you'll have authority to act. And when you are engaged in decision making, when you're engaged in commercial activity, you'll be doing so not on your own behalf, but as an agent for the company that you work for. And that's certainly a way upon which we engage in commercial transactions, commercial activities. Or certainly an alternative to that is, as is the case for most of you now, when you engage in some form of commercial activity, when you buy and sell goods and services, you do so in your own name. You do so as an individual. And that's another way, certainly, that we view and we think about entering into commercial activities. For business associations, we take commerce, we take business, we take transactions, and we organize the manner upon which those businesses operate. And there are three main classifications for the manner upon which we engage in business. The first is the sole proprietorship. The second is the corporation. And the third classification is the partnership. And it's important when you are involved in some form of business activity that you be cognizant, that you be aware of who is and who are the parties to that transaction. Is it you alone, individually, whereupon you would be deemed legally a sole proprietor? Is it you in combination with one or two other people? You haven't incorporated yourselves, but you agree to be parties to a transaction together, like renting a house for living next school year. This would mean that you would be under the law viewed as a partnership, where you would share joint and several liability amongst the partners. Or is the transaction one that involves a formed legal entity that is separate and distinct from the individuals who have formed the entity? And that, in sum or in short, is what we deem to be a corporation. It's important for you to be able to quickly and accurately recognize who are the parties to a transaction, who faces potential liability. We, in the United States, have a way of kind of trying to create little silos for purposes of doing business. You drive down the street and you see a restaurant, and you see the name on the sign of that restaurant, and you think to yourself, well, that's Acme Restaurant. And I say to you, well, that's probably three different corporate entities transacting business as Acme Restaurant. There's probably a corporation that has been formed to hold title to the land upon which the restaurant is situated. There's probably a separate corporation that has been established to hold title to the liquor license so that Acme can sell liquor to its patrons. But we recognize that when there is the sale of liquor, there is enhanced potential for liability. And the owners of Acme Restaurant probably would like to separate out the liability associated with liquor from the potential risk of liability associated with ownership of the land. And then there's probably a third corporation that is established that actually operates Acme, that hires the employees, that enters into contracts for the purchase of product and produce, that advertises. And so when you see Acme's restaurants as you're driving down the street, you are probably looking at least 3 different corporate entities that come together to operate as Acme. I've suggested to you this before, but when you watch a lawyer read a contract that has been memorialized into writing, if you notice, what the lawyer will often do is skip to the very end before actually reading through the terms of the contract. By skipping to the end, what the lawyer is typically doing is checking who it is that is obligating themselves to that contract. Who are the actual parties to that contract? I've given you this example, I think, once before, but it used to kind of drive my kids a little bit crazy when we would go on, summer vacations, and we would stop, and the kids would always want to stop at a McDonald's or a Burger King. And before entering the fast food restaurant, I would always pause for a moment and read in the entranceway the sign where the actual owners of the restaurant were letting you know that while they are franchisees of McDonald's or Burger King, they were actually Acme Limited Family Corporation 3 transacting business as McDonald's or Burger King. And this would be the part that would always annoy my children, but they would be talking about how great it was to be eating at McDonald's or Burger King, and I, of course, would have to point out, no, we're eating at Acme's, and they're a franchisee of McDonald's or Burger King. But you ever look at the receipt that you get, and it's very clear that you have transacted business with an entity transacting business in the name of some other entity. Some years ago, I had the opportunity to act as an extra on a movie that was filmed on Michigan State's campus. The film was a Batman versus Superman. I made it onto the screen for about 1.3 seconds. It was a wonderful experience, had a lot of fun, and I had decided that I was going to take my pay and I'd frame it, take the check that they were going to pay us and frame it and put it someplace, near my television so that I could tell the story of what it was like to be an extra in a blockbuster film. Well, in my humble opinion, the movie wasn't that good to begin with. I wasn't in it very much. And lo and behold, rather than signing a contract with Warner Brothers, the production company on the film, prior to any of us allowing or being allowed on set, we were given contracts. We could sign them or not. And if we didn't, then we had to leave. And the contract was between ourselves and Acme Extras of Michigan, LLC 2. Acme Extras of Michigan, LLC 2 is undoubtedly a entity that was formed by Warner Brothers that had no assets. But what the lawyers at Warner Brothers were not going to do is allow any of us to become employees of Warner Brothers Instead, we became employees of Acme. We were on site for 2 evenings. We each got paid about $100. And yes, I cashed that check because it was going to be a little different having a check framed that said Acme as opposed to Warner Brothers. This is not uncommon in the manner upon which we engage in business in the 21st century. And one of the things that I will do in this section is to highlight for you how easy it is to establish a corporate entity, to establish a limited liability company, and how important it is for you to try to limit your own exposure to potential liability by, when the circumstances fit, incorporating your business. But before we get there, let me go to the lecture slides. And let me, again, highlight for you the 3 major ways upon which we engage in business, the 3 classifications, the 3 major types of business entities that exist: the sole proprietorship, the corporation, and the partnership. Now, within these classifications, particularly within the law of corporations, we do have different ways upon which we subclassify corporations. You can have corporations that are for a private purpose, or a corporation that is established for a public purpose. You can have corporations that are established for nonprofit. You can have corporations that are established for ecclesiastical. You can establish a church in the form of a corporation. You can establish a corporation for the operation of a profession, like a lawyer, a doctor, an engineer, an accountant. And within the law of partnerships, we even also see certain subclassifications of partnerships. For our purposes, I want you to be able to identify the different types of business, entities that exist, notably the way that we classify businesses. And this is the sole proprietorship, the corporation, and the partnership. Perhaps the easiest for us to comprehend is the sole proprietorship, because the sole proprietorship is you and I. It is any time as individuals alone we engage in a commercial activity. When we do not form a corporation, when we are not acting in unison with another person or persons as partners, when we are not acting as an agent for some other entity, when we haven't incorporated our business, by default, when it's just us, we are sole proprietors. And we have all engaged in commercial activity, and we will all continue to engage in commercial activity as sole proprietors. There is no legal distinction between ourselves and the operation of the business that we are engaged in. Any of you that have ever babysat as kids, any of you that have ever sold goods or services online, any of you that have run out the table in lemonade for a little stand at the bottom of your driveway, anybody that's ever raked leaves or shoveled snow and been compensated by the neighbors, any of you that have ever tutored another and been paid. These are just examples upon which it would be highly unlikely that you would have incorporated a business for that activity. Instead, you've engaged in that behavior, you've been paid. I'm sure that all of us in all of those circumstances have paid the appropriate tax. At least we should, when we engage in business as a sole proprietor. But there is no legal distinction between ourselves and the operation of the business. Now, the legal effect of there being no distinction between ourselves and the business within which we operate is it doesn't cost anything to operate a business as a sole proprietor. There is no barrier or formalities to entry. All of the management decisions are made by us personally, if there are management decisions to be made. We can actually, with states, and in Michigan, particularly with the county, even register a name as a sole proprietor. I can be Michael Behan, individual sole proprietor, doing business as, old guy lawn raking services. But one of the features of the sole proprietorship, the key feature of the sole proprietorship, if you will, the impact of the sole proprietorship from a legal perspective is unlimited personal liability. Unlimited personal liability for any of the losses that are sustained by the business activity, because we are personally engaged in the business activity. There is no legal distinction between ourselves and the business activity. And so if there is a tort committed, if there is a contract breached, if there is a statute that has been violated, that's on us personally. And the effect or impact is that if there is a judgment that is entered, all of our assets are subject to collection to satisfy that judgment. I decide that I want to use my skills as a woodworker, as a handy person with wood to build baseball bats. And so I assemble some lumber, I go into my garage, I spend some time, and the result is a baseball bat. And I get pretty good at it. And all of a sudden, the baseball bats that I have created in my garage are in demand. And someone who has bought one of those baseball bats from me gets injured because the baseball bat perhaps breaks in half while it's being used. And whoever's been injured wants to hold me liable. They want to sue me for negligent design or negligent manufacturing of that baseball bat. Well, if it is me alone, unincorporated, who has produced that bat and sold that bat, then if I am liable, I am fully and personally liable for the losses sustained by the individual who was injured. This is why when I have assets that I wish to protect, or when there is conduct that I am engaged in that could lead itself potentially to liability, I would be very wise to incorporate my business. So instead of me being the person who is producing the baseball bats and selling them, it's Behan Baseball Bat Company that is producing the baseball bats and selling them. Now, I may be the sole owner of Behan's Baseball Bats, but Behan's Baseball Bats, if it is incorporated, is a legal entity that is separate and distinct from me. Which brings us then to the most significant, the most consequential, the most important of the business entities that exist under the law, and that is the corporation. I think sometimes people think that you incorporate because there's status. Instead of it just being Behan who's selling his baseball bats out of his garage, if he creates and establishes Behan Baseball Bat Company, that seems to be a little bit more prestigious. There's greater status in having a company. And that may certainly be true. That certainly is not an inaccurate statement, that there is perhaps more status involved with incorporating a business. But the purpose, the reason, the motive of creating a corporation is unquestionably what you see on the top line here, and that is to separate the business from the actual owners of the business, such that the business will be liable, but not the owners, not the shareholders, not the people themselves. The main reason that we incorporate, the main reason that we establish corporate entities is to try to insulate ourselves personally from the liabilities associated with the business. There is not even any other close reason or motive than the limiting of liability. Corporations are legal entities separate and distinct from those individuals who have created the entity, who own the entity, who manage the entity, who are employed by the entity. I suspect that there are some of you, perhaps many of you, who are watching this asynchronous lecture, who own shares of stock in companies that are sold on national stock exchanges. You realize that you bear certain risk in owning stock. But that risk is not that the company could get sued and you could be asked to bear responsibility for the actions of that company. The risk that you bear when you own shares of stock is that the company could fail and that your investment becomes a total loss. If you hold stock in General Motors Corporation, General Motors Corporation is sued frequently. Allegations of faulty design, breach of contract. You don't worry at night about being held personally responsible for the judgments or settlements against General Motors when they're sued. Because you're a shareholder, you're not the entity itself. Now, when we think of corporations, I think we think of the Apples and the IBMs and the Coca-Colas and the General Motors and the big name brand types of companies that everybody is familiar with. The overwhelming vast majority of corporations that exist in the United States are actually privately held corporations, corporations that you or I might establish. I have a client, been a long-time client, that every time this client buys a rental property, the client establishes a limited liability company to take title to that rental property. When the rental property is open for business, if you will, when the individual rents the property, the rental agreements are between the LLC and the tenant. And for each of those rental properties, the client files a separate tax return. The owners of those limited liability companies happen to all be actually owned by one corporate entity, kind of a holding company, if you will, for each of those properties. And I think she's now up to about 14 rental properties down in the Detroit area, all of which are placed into their own cylinder, if you will. What owners of businesses don't want is they don't want the domino effect of a judgment or loss or failure of one business affecting the rest of the businesses that they might own. And so she has been sued. She has faced loss relative to certain rental properties, but those losses are sustainable, and the actual losses that are suffered are limited to each of those individual properties. Now, we're going to talk a little bit about the internal operations of corporations, but what is important, I think, from the outset to understand about corporations is that they are creatures of state law. In the United States, we must go through the formalities of filing what are known as articles of incorporation with a state, and the state will then either accept or reject the articles of incorporation. But if the state accepts the articles of incorporation, you now have an entity, a business that exists separate and distinct from the individuals who have filed the articles of incorporation, the individuals who are most likely going to be the shareholders, the owners of the corporation. Corporations have so much of the same legal rights as we as individuals have. Corporations can hold and own property. Corporations can be sued and file lawsuits. Corporations can have tax identification numbers, like we have Social Security numbers, which allow corporations then to have bank accounts and operate in financial transactions. Corporations can be held responsible under the criminal code. Clearly, corporations themselves can't be incarcerated, but the individuals who have engaged in criminal wrongdoing, even in their and under the guise of acting on behalf of the corporation, can be criminally prosecuted. And certainly corporations can be fined. Now, when you have a corporate entity, because it is a non-human legal entity, you have to assign certain responsibilities to human beings, to individuals. One of those responsibilities is who will be responsible for service of process, who is the individual that will be responsible for actually receiving legal notifications that would be served upon a corporation. If you or I get sued, the documents will be given to you or I personally. Well, if Apple or General Motors or IBM gets sued, you don't get to just go find, the closest store and drop off the lawsuit. There is an actual individual that will be identified as being the responsible party, the resident agent, as we refer to that person as, for purposes of receiving service of process. And every business that transacts its business operations in the state of Michigan will have to register an agent for service of process. If you're going to do business on a ongoing basis in the state of Michigan, you've got to designate who the resident agent is for the operation of that business, and particularly if there's notification of a lawsuit or alleged violation of the law, who gets notice. The concept that you see at the bottom of this slide, the alter ego and the piercing of the corporate veil, this is something we're also going to talk about and look at, but it's kind of the exception that proves the rule. When you have a corporation that is established, you do not get the opportunity to successfully hold the owners of that corporation liable for the losses sustained by the corporation. This is a veil that cannot be pierced, with certain exceptions. But these are exceptions, to me, that kind of prove the rule. If the corporation is established for an unlawful purpose, if the corporation exists simply to commit crime, then certainly you can pierce the corporate veil and hold the individuals personally responsible, personally liable. Bernard Madoff, for those of you that remember, is a classic example of an individual who incorporated and operated a business to perpetrate criminal activity. There are ways that we will classify corporations that I'm going to get back to in our next asynchronous session. But suffice it to say, if individuals in good faith attempt to form a corporation, we will provide those individuals with the shield of corporate protection, even if there is some small deficiency that exists in the formation of the corporation. As is the case with all business entities, corporations are creatures of state law. They're established under the laws of a state. Every domestic corporation in the United States has a forum state. There are articles of incorporation. The business itself is formed within a state. Oftentimes, historically, it was Delaware. Now states have tried to make it very easy for you to form and establish a corporation within a state. And I'll talk to you about the manner upon which that occurs in our next session. But before I conclude with this introductory session to the law of business associations, business entities, I want to talk about the partnership. Because the partnership is the third type of business entity. It's the third way upon which we will classify the manner upon which persons engage in business. And the partnership is the law's answer to what do we do when we have two or more individuals who are engaged in a commercial activity and they haven't incorporated that business? What do we do for purposes of liability, and how do we go about the splitting up or the sharing of profits? Now, let me be clear when I say to you, you don't want to, with very limited exceptions, engage in business as partners. It will be much better off for you to incorporate the business rather than to engage in business as partners. Partners is more a business association, a business entity, a business type that exists by default. The classic partnership circumstance that most of you would be familiar with is the renting of a house or an apartment by college students. When you and 2 or 3 or 4 of your friends go over to Spartan Avenue or Stoddard Street or any of the other areas in East Lansing, and you rent for 9 months or 12 months, either one of two things will happen. You will be presented by the landlord with a contract that is individual to you and you alone, or, which is far more likely, you will be presented with a contract that will be between the landlord and 2, 3, 4, 5 of you collectively. And this collective ensemble, if you will, of you and your friends is by law a partnership. And the significance of the partnership is that each of you bears full responsibility in total for the contract. So if you're renting a house, 3 of you, 4 of you, 5 of you, at $2,500 or $3,000 or $4,000 a month, each of you is fully responsible for the $25,000 or $3,000 or $4,000 a month. The landlord can actually collect that from each of you if it's not paid. Now, each of you can turn on each other and say, hey, you owe me, you've got to contribute. But the contract imposes what we call joint and several liability amongst the partners. The idea of a partnership is there's many activities that we engage in with others because we cannot afford to engage in that activity alone. And so out of necessity, groups of individuals will combine their resources. But the downside, the cost associated with engaging in business as partners, is the concept of joint and several liability. You are fully responsible in total for the full contract. You might sit back and say, well, hey, here's what we'll do is we'll incorporate and then go enter into a contract. Well, good luck with that. Because what happens is that when people incorporate and then want to enter into contracts, those who enter into the contracts with those who have incorporated will typically say, that's great, you can incorporate, but I'm still going to require a personal guarantee. Which defeats then the purpose of incorporating, at least to withstand contract liability. Remember, because as we move forward, it's important to be aware of, be cognizant of the concept of liability and how liability occurs. Liability occurs when there's the violation of a statute, that's statutory liability. Liability occurs when there's the violation or breaching of a contract, that's contract liability. And then liability occurs when someone has committed a tort, that's tort liability. And those concepts are going to be concepts that we're going to be talking about in each of these sessions as we move forward. Why do people incorporate? To separate the liabilities of the business from their own personal exposure or risk of loss for those liabilities. That's clearly the best way within which we can protect ourselves and our assets when we do business. The difficulty certainly is that if you are going to incorporate your business and you are going to be seeking financing, those who are going to be providing you that financing are going to say, fine, we'll give you the financing, but you're going to sign a personal guarantee so that we can come after you personally for any breaches of the legal obligations by the corporation that you have established. So there's only so much limitation that can occur when you incorporate. But what's really important always is to be well aware of who it is that you are entering into a business transaction with. I did not enter into a business transaction, nor have I ever entered into a business transaction with Warner Brothers Motion Picture Studios. But I did enter into a commercial transaction, a business transaction with Acme Extras, and Acme is no Warner Brothers. Let's put it that way. That's good for the first asynchronous session on the overview of business associations, business enterprises, business organizations. We'll come back and look more specifically at the different classifications within the law